Have you ever stood in your own backyard, or maybe just looked at a big office building downtown and felt that powerful sense of ownership, like this is my space or their space, and we can do whatever we want with it?
Oh, yeah, it's a foundational feeling, isn't it? That sense of autonomy and control. But what if I told you that beneath that feeling lie these invisible layers of control, intricate rules, and fascinating complexities that govern every single patch of land, whether it's your cozy home or some bustling commercial
Things
hub?
you might not even know exist.
Exactly.
Okay, let's unpack this. Today, we're diving deep into something fundamental yet often overlooked: public and private land use controls, also known as encumbrances. Our mission for this deep dive is to kind of pull back the curtain and reveal the surprising, sometimes counterintuitive, rules, rights, and restrictions that truly govern what you can and can't do with land.
That's right. We've pulled together a collection of sources outlining these legal concepts, and our goal is really to give you a shortcut to understanding these invisible forces shaping our physical world. Think of this as your secret weapon to truly feel well-informed about something that impacts us all every single day, often without us realizing it.
Get ready for some serious aha moments, maybe surprising facts, and crucial knowledge that will fundamentally change how you look at every plot of land from now on.
Yeah.
So where do we start? I guess with the biggest influence of all, the government's hand in land.
Indeed. And to simplify the main governmental rights in land, we use a handy acronym, PEAT.
Pete, okay.
Yeah, PETE. That stands for Police Power, Eminent Domain, Taxation, and Escheat. Each one gives the government a unique kind of overarching authority over private property.
Right. Let's really dig into P for police power.
Yeah.
That sounds incredibly broad. How does this power actually manifest and, affect what we do with our property?
Well, police power is essentially the government's inherent right to regulate and control how property is used, specifically for the health, safety, and general welfare of the public. The key insight here is that this isn't just about big abstract laws. It's why your neighbor can't, open a chemical plant next door, or why your house needs a smoke detector.
Right.
It's the invisible hand ensuring a livable and safe community for everyone.
That's fascinating. So what's the most common, maybe everyday way we encounter this police power, maybe without even realizing it?
Without a doubt, it's zoning.
Zoning.
Zoning regulations are local laws that dictate how land can be used. For instance, if you see R1 zoning, that means it's restricted to residential single-family homes only. It literally shapes our neighborhoods.
What if you have, say, an old corner store that's been in the same spot for 50 years, and then the whole area gets rezoned for residential only? Does that store just have to shut down? That feels a bit unfair.
Yeah, that's where a non-conforming use comes in. This is a really interesting aspect of police power, shows its flexibility. If a use was perfectly okay under the old rules, but new zoning prohibits it, it's generally allowed to continue. It's grandfathered in.
Okay.
It's automatic. You don't need an application or a hearing. However, here's the kicker. It cannot be altered or expanded without specific permission. And if the property is destroyed, say, in a fire, that use might not be rebuilt without explicit approval. Crucially, though, it's not a violation. It was perfectly legal when it started. It just doesn't conform to the new rules.
So a non-conforming use is allowed to continue. But what if I want to do something that does clearly violate current zoning? Like maybe I want to extend my garage a few feet beyond the setback line. Do I just have to live with a smaller garage?
Then you need a variance. A variance is when you apply to the local zoning committee, essentially asking for an exception to those strict zoning rules. There's usually a public hearing.
Oh, I bet those get lively.
They can. All the neighborhood property owners are invited to voice any objections. If it's granted, that variance isn't just for you. It actually goes with the property when it's sold, meaning future owners can benefit from it too.
And what about things that seem out of place but are actually allowed, like maybe a school or a church right in the middle of a quiet residential subdivision? How do those get a pass?
Those would likely be conditional or special uses. These are uses that are specifically granted because they're deemed to benefit the neighborhood. They can be approved by a zoning committee or sometimes even an HOA. And speaking of special uses within residential areas, there are also planned unit developments, or PDs.
PDs. Okay, that sounds less interesting than a dessert menu item.
Chuckles slightly. Maybe not as sweet, but PDs are actually quite innovative, and for residents, they can be pretty good. The aha here is that PDONs let developers build more homes, that's the higher population density, by clustering houses together.
Right, so they're closer together.
Yeah, and this clever approach often leaves more green space for residents than traditional layouts. There are three common characteristics. The developer provides and designs that green space, then a nonprofit HOA will maintain it, and residents will typically pay an extra tax or fee to the HOA specifically for that upkeep.
Interesting. It's a whole different model.
It's a unique way communities are designed.
We have zoning dictating use and special exceptions like variances and PUDs. But what about when different types of land use kind of butt up against each other, like a bustling shopping center right next to single-family homes? That sounds like a recipe for conflict.
It can be. That's where buffer zones come in. These are specific areas of land designed to separate one land use from another, acting as a kind of transitional space.
Like a barrier.
For example, you might see apartments used as a buffer zone, strategically placed between single-family homes and maybe a noisy retail area. This minimizes friction between incompatible uses. Governments also use buffer zones around protected areas like wetlands or coastal properties to keep construction a set distance away.
Okay, that makes sense. And finally, still under police power, we also have building codes. I imagine those are pretty straightforward.
They are, relatively speaking. Building codes are specific governmental requirements for construction, designs, materials, safety guidelines. They're why new construction frequently requires a certificate of occupancy before it can be legally occupied.
Right, to make sure it's safe.
Exactly. It's the government's way of ensuring the structure itself is safe and up to modern standards, protecting everyone who lives or works there.
All right, that's police power, the broad regulatory hand of government. But what if the government needs your specific piece of property for a public project, say a new highway or a school? That's where E in Pete, eminent domain, comes in. Feels like the most direct way the government can exert control.
It certainly is. Eminent domain is the government's right to take private property for public use, and they do this through a legal action called condemnation.
Condemnation, right?
What's fascinating and critically important here is that this is the only time the government must compensate property owners for taking their land. They can't just grab it. Fair compensation is constitutionally required.
Wait, so the government initiates taking your land. But I read about something called inverse condemnation, where an individual forces the government to buy their property. That sounds like a pretty big twist. What kind of situation would trigger that?
It is a significant twist. Inverse condemnation typically comes up when the government's actions, maybe through excessive regulation or perhaps creating some kind of nuisance, effectively render a private property unusable or significantly devalued without formally taking it through condemnation.
So the government ruins your property value without actually taking the title.
Pretty much. In those cases, the property owner can sue the government, essentially forcing them to condemn and purchase the property because its utility has been destroyed by their actions. It definitely keeps things interesting and provides a check on government power.
Fascinating. Now on to T for taxation. I imagine this is pretty familiar to most of us.
Absolutely. Property taxes, the unavoidable truth of land ownership. Property taxes are ad valorem taxes, which just means, according to value, the more valuable your property, the higher your tax.
Makes sense.
Crucial point that many might not realize. Property taxes are the highest priority lien on real property. Unpaid taxes automatically create this lien, and if there's a foreclosure, property taxes are always paid first, before the mortgage, before anything else.
Wow, always first, no exceptions.
The government gets paid first.
That makes a lot of sense, I guess. And finally, E for Escheat. This one sounds a bit archaic, like something out of an old dusty law book.
It does sound old, but it's still very relevant today. Escheat is simply when property reverts to the state. This happens if someone dies without a will and they have no identifiable heirs, or if property is simply abandoned.
Abandoned, like someone just walks away.
Legally, yes. Abandonment in this context describes an act of surrendering or forfeiting rights or property. The interesting reason behind Escheat is purely practical. It ensures that no land remains unowned. It prevents legal limbo and maintains clear title and control over all property within the state.
So no ownerless land floating around.
Exactly.
Okay, so we've thoroughly explored, Pete, the formidable governmental controls. But surprisingly, maybe even more restrictive sometimes, are the private agreements and these sort of hidden claims that can significantly dictate what you can and can't do with land. Let's pull back the curtain on those private controls now.
That's right. And the most common examples you'll run into are CC&R's covenants, conditions, and restrictions. You'll often hear them just called deed restrictions or deed covenants.
The CNR.
Homeowner or property owner association regulations, like in condo complexes or subdivisions, they're very similar to deed restrictions, but specifically applied just to those communities.
So if I buy a house in a neighborhood with an HOA, I'm essentially signing up for these rules as part of my purchase, correct? Like I'm contractually obligated.
These private controls of land use are contractual obligations that a buyer agrees to when they purchase the property. Deed restrictions are imposed to control a huge range of things: land use, development, specific construction methods and materials, even aesthetic requirements like requiring garages to face the rear or dictating exterior paint colors.
Wow, they can get really specific.
Oh, incredibly detailed sometimes.
And how are these enforced? It's not like the city zoning board is going to, step in if I paint my house the wrong shade of beige.
Right, the government doesn't enforce these. They are found in a recorded document called a Declaration of Restrictions, and they're imposed by the original grantor, usually the developer. If violated, other property owners who are bound by the same deed restrictions can bring civil court action.
So your neighbors sue you.
Essentially, yes. The court can then issue an injunction to enforce the rules. Your neighbors are basically the enforcers.
Okay, here's where it gets really interesting for me. What happens if both deed restrictions and zoning apply to a property? Do I follow the government's rules or the private ones? Which one wins?
This is a crucial insight, yeah, and something every property owner should absolutely know. If both deed restrictions and zoning exist, you always obey whichever is the most restrictive or limiting.
The most restrictive.
Always. This means the government zoning might allow something, like maybe mixed-use commercial, but your neighborhood's private rules could still say no, maybe specifying only a hospital can be built there. And those private rules almost always win out in court, often permanently shaping your property's future. Deed restrictions are typically permanent in most cases and usually control present and future owners and tenants.
That's a huge takeaway. Wow. So, okay, beyond these specific restrictions, let's talk about encumbrances more broadly. What exactly are they?
Right. An encumbrance is just a general term for a limit on a property or a limit on a property owner's rights. It might or might not also be a cloud on the title, which just means it could raise questions about clear ownership or create a challenge when you try to sell.
So like hurdles or limits.
Exactly. Think of them as additional layers of rules or claims on the property that aren't necessarily about outright ownership, but they certainly affect it.
Like a reservation. That sounds like a seller keeping something back when they sell.
That's exactly what it is. A reservation is when the grantor, the seller, withholds title to a part of the land described in the deed. For example, they might sell the surface rights, but reserve an easement to access a well on the property, or maybe they reserve the mineral rights beneath the surface.
Okay, what about something less formal? Maybe like a fence or a shed that's accidentally built slightly over the property line onto a neighbor's land?
That's an encroachment. It's when a structure or improvement physically overlaps or trespasses onto another person's property. Yeah. They must be disclosed during a sale, and figuring out if there's an encroachment requires a professional survey. The injured party, your neighbor in this case, has the legal right to demand its removal.
Get your shed off my lawn.
Pretty much.
So an encroachment is a physical trespass. But what if someone needs to use part of your land, like for access, without actually owning it? This sounds like a common scenario, especially maybe in rural areas or with shared driveways.
That's an easement. An easement allows for the limited use or enjoyment of another's land. It is considered a right in land, so it really should always be created in writing and recorded to be legally binding. The key here is use without possession.
Use without possession. Okay.
You don't know it, but you have the right to use it for a specific purpose, like driving across it.
How do these easements typically come into existence? Do they just sort of appear out of thin air?
Not at all, no. Easements can be created in several ways. Often it's by an express written grant, or maybe an implied grant, just by agreement between the parties. It could be through reservation, like we just mentioned, where a seller keeps an easement when they sell off part of their land.
Okay.
Or even surprisingly, by limitation or prescription, which is basically acquiring an easement by using someone else's land constantly, openly, and without permission for a specific long period, often 10 or more years.
Wow, so you can get rights just by using it.
Under very specific conditions, yes. They can also be created by necessity, like if a property is landlocked and needs access, or even by condemnation if the government needs it for public use like utilities or railroads.
And once an easement exists, how does it ever end? Can you get rid of one?
Yes, easements can be terminated. Common ways include by merger.
Merger?
Yeah, where one party buys the adjacent property so the easement isn't needed anymore. Or by a recorded release where the person who benefits from the easement formally gives it up. Or even by abandonment if the actions show they've given up those rights.
Okay. This is where the dominant and servient estates come in, right? It sounds like something out of like a medieval drama with lords and vassals.
Chuckles. It does sound a bit like that. In an easement appurtenant, which usually involves two adjacent pieces of land, the dominant estate is the owner who benefits from the easement. For example, they get access to their landlocked property by crossing the neighbor's land.
So they dominate the situation, kind of.
You could think of it that way. The property with the road or access point is the servient estate because its use is limited or encumbered by the easement. It serves the dominant property.
The dominant property needs the servient property for its benefit. Okay.
Exactly.
So if John owns a large property with his home way in the back, and he sells the front portion to a developer, but he reserves an easement to drive across that front part to get to his house, that's an easement appurtenant.
Exactly right. That easement for entry and exit, the legal terms are ingress and egress, is an easement appurtenant. It's tied to the land itself, not just to John. 4 key facts to remember. It goes to the buyer when the dominant land is sold, the dominant property benefits, the servient property is limited, and importantly, a utility easement, which is a different type, isn't affected by any sale.
Okay, so what's that different type? An easement in gross. That belongs to a person or a corporation, not a specific piece of land itself, like the power company's right to run lines across anyone's property.
Precisely. That's an easement in gross. No matter who owns the land underneath those power lines, the easement still belongs to the utility company. It's a right held by an entity not tied to a neighboring parcel.
Got it. Now, what about something that feels like an easement but isn't quite as formal or permanent? Like if my neighbor just says, yeah, sure, you can cut across my lawn for a shortcut today.
That's typically a license. It's temporary permission to do a particular act upon the land or property of another. A theater ticket or a sports event ticket is actually a classic example. It grants you the use of one specific seat for one performance, just temporarily. A license is similar to an easement, but much more limited in duration. It's often just given verbally, and crucially, it can be easily revoked by the property owner at any time. It is not a right in land. Granting temporary permission to cross someone's land is another very common example of a license.
So you can temporarily cross someone's land if they give you a license, but it's not the same as a permanent, legally binding easement.
Got it. And now for one of the most surprising ways to acquire land without actually buying it. Adverse possession. We often hear this called squatters' rights, and it almost sounds, well, unbelievable. It is truly fascinating, and yes, it's a real thing, although maybe not as common as people think. Adverse possession allows property to be acquired from the rightful owner through the statute of limitations. That's a specific legal time frame, often many years, during which a claim must be made or it's forfeited.
So you just move in.
Well, it's much more complicated than that. For it to happen, the occupancy has to meet very specific, strict legal requirements. It must be hostile, meaning without permission, visible or open, actual or notorious, so the real owner should know, continuous and distinct for the entire statutory period.
Wow, that's a lot of hurdles.
It is, but it's a real-world example of how an individual could potentially get title to real property without ever receiving a deed. It's rare, but it does happen.
That's wild and honestly a bit scary if you're a property owner.
And
finally, lis pendens. This sounds very official, like something you'd definitely see in a court document.
it is official. A lis pendens, Latin for litigation pending, is a recorded notice filed against a specific property, meaning that some form of lawsuit has been filed, but it hasn't been resolved in court yet.
Why is that important?
It's crucial because if it's not settled prior to closing on a property, that pending lawsuit, whatever it is, may become the responsibility of the new owner. You often see a reference to a lis pendens filed when a mortgage is going into foreclosure, basically alerting potential buyers that there's ongoing legal action concerning the property.
Wow. Okay. We've certainly unpacked a lot of layers today. From the government's broad PEAT powers, police power, eminent domain, taxation, and Escheat, right down to the intricate private controls like CC&Rs, easements, and even these really surprising concepts like adverse possession and lis pendens. Before this, I just thought zoning was, zoning. But understanding these non-conforming uses, variances, and especially that most restrictive rule concept really makes you appreciate the layers of history and flexibility involved.
Absolutely. And how much you really need to know before you buy or even just deal with property.
Yeah. Understanding these public and private controls just gives you a much deeper appreciation for the complex web of rights and responsibilities that truly define property ownership. Knowing these terms can genuinely protect you. It can inform your decisions when you're buying or selling, or honestly, just satisfy your curiosity about the invisible forces shaping the world around you every single day.
So, the next time you look at a property, maybe ask yourself, will you see just a building and land, or will you start to notice those invisible layers of peat and the private encumbrances that truly shape its destiny?